Welcome, everybody. Nice to see you guys today. Huge news out of the legal world. Justice Breyer's cell phone rang today during oral arguments. So that seemed to be dominating my Twitter feed, which probably says a lot about who I follow on Twitter. Raise the question, do the robes have pockets? I guess they must. And last word is nobody could identify the particular song that was playing on the ringtone. So I guess it happens to the best of us, right? Okay, we are marching right along through the semester. Today we're going to finish up employment discrimination, which means Thursday we'll do workplace respect and bullying. That'll be the final content session for the class. Next Tuesday I will do a final exam review, which I hope you will find useful. I'll have some slides, but I'll also take questions. And next Thursday, I don't believe we'll have to have class, so you guys can have that day to finish Serial Part 5 with your groups. It's kind of a fun one. Encourages you to get out and walk around a little bit. So we are moving right along. This module, you notice it has a fair amount of supplementary material, including 2 pretty long cases. I don't expect you to read those for the final or anything. They're more just if you have an interest in this stuff, you can read them. There's a little disclaimer statement thing that could be used on an employee handbook. There's a little thing, employee or independent contractor, which applies. You can use if you want. And then I have a little fact sheet on the updates to the Americans with Disabilities Act, which we'll talk about today. But none of this is required reading. Actually, the Uber hammer attack isn't either, although it's good reading, but it's not required. So don't freak out and think you have to read these big, long McDonnell Douglas and Young versus UPS cases. Sometimes I get people who are like, well, you know, can you show an employment law case that goes through the burden shifting framework, which I'll talk about today. And so those are kind of the big cases that all the other cases cite to, all right? So let us talk about employment discrimination. We finished up last week talking about wrongful discharge and some of the remedies that you might seek and things like that. So a little bit inside out, but let's go today to what kind of events could lead you to file a claim in that regard, and what is the law at work in terms of how you relate to your employees and the other folks at your office. So we're going to touch on a number of different kinds of employment discrimination. So the first 2 slides I'm going to show you here, these are procedural. All right? Hey, Justice Breyer, are you here in the courtroom? Somebody's phone went off. So these are procedural, and I want to talk about these. These are called burden shifting frameworks, okay? That's a weird phrase, but what I want you to know is that these 2 flowcharts, one or the other of these is what a plaintiff has to get through before their employment discrimination case can ever come to trial. So there is a lot of work on the front end. I mentioned this a little bit when we had our civil litigation section around Module 2, Module 3. I said there's this motion practice, and that basically has to do with the lawyers filing different motions, different requests with the judge. The defense is obviously going to file motions to dispose of the case before trial. They're going to say, look, the case has no merit, it shouldn't even get there. And the plaintiff is going to resist those motions and say, yeah, we do have merit, we should get to trial, all right? So there's a lot of work for a plaintiff that has to be done before you can even ever get to trial, all right? And in fact, these 2 frameworks, they take place in the court system. I'm going to show you that there's work to be done for the plaintiff before you even get in the court system. So it's a long road to bring an employment discrimination case as a plaintiff. But we'll set aside that other little bit for now, and I just want to show you these burden shifting frameworks, all right? And we can come back and revisit these, and I certainly will revisit them in the review, but I want you to think about the 2 different kinds of discrimination that we normally see. And these are kind of an overarching sort, all right? And employment discrimination can take place with regard to really any kind of tangible employment action. So what is that? Well, that's like a decision to hire someone or not hire someone, a decision to fire someone, a decision to promote someone or move their job within an organization, or possibly a decision to demote or discipline an employee. So really, anytime the organization takes action for or against a person, they have to make sure that they're doing that legally. That's not usually a problem, but sometimes it can creep in. These two burden-shifting frameworks that I'm showing you here, the examples I'm going to show you, are related to hiring, okay? So the second one is almost a little bit easier one to start with. So one kind of employment discrimination is called disparate treatment. It might also be called intentional discrimination. So suppose you have an employer that just doesn't want a certain class of people working there. Maybe they don't want women. Maybe they don't want non-white people. Maybe they don't want non-Christian people working there, okay? Generally speaking, it's illegal to discriminate based on those protected classes. Very few employers are going to be stupid enough to come right out and say, you know, women need not apply or something like that. Sometimes that happens, but very rarely. What they're going to do is they're going to give alternate reasons, or they're just simply not going to hire people from that class of people that they don't like. All right? So suppose you apply for a job, and you're a woman, and you believe, and you don't get the job, and you believe the motivating factor was your gender, okay? So if you want to have a trial on that issue, here's what you've got to go through. The first thing you have to do is establish a prima facie case. It's a little bit of Latin. It just means on the face. Basically, it means you have to show enough evidence up front that it appears plausible that your claim has some merit to it. So first thing, if you're going to claim discrimination based on a protected class, you got to be in a protected class. So for my example, gender is a protected class, okay? Whether you're male or female or whatever, it doesn't protect just one gender. It protects you from being discriminated against based on your gender, okay? So you say, look, okay, I am this gender. I applied for the position. I met all the minimum qualifications. I was rejected. And the employer continued to accept applications. And in fact, for the 10 openings that they were hiring for, they hired 10 men and no women, okay? So if you can sketch out that prima facie case, then you'll probably survive the kind of first level motion to dismiss. So the burden of proof is on you there. Then the burden shifts over to the employer if you survive that first part. And then the employer has to show legitimate and non-discriminatory reasons for the action. All right? Now, very few employers are going to be so dumb at this point as to say, yeah, you got us. We just didn't want women working here. We discriminated. No, they're going to say something else. They're going to say, we hired candidates that were more qualified. Some very nebulous thing, usually, right? We hired people who had better experience, better resumes, all right? So if they can cross that hurdle, and it's a pretty low hurdle, then it comes back to you, and you have to show that was a pretext. In other words, that was a made-up reason that they gave here in step 2. And you have to show that your protected status was the determining factor in the decision. How do you do that? Well, there's a couple ways. You're in litigation now, even though you're short of trial, so you know you have discovery going on. Maybe these folks are dumb enough to send emails or internal memos or guidelines saying, we don't hire women, we don't want women, say whatever you have to say to get them out of the applicant pool. Maybe they're dumb enough to do that. Or maybe you have to hire an expert witness to testify that, looking at the numbers, okay, they've had this many male applicants, and they've hired all of them, and they've had this many female applicants, and they've hired none of them. They appear to be discriminating. And then, of course, the company will have their own expert who will say, no, there were valid reasons, and here are some of the reasons, and we're not discriminating. But if you can get past this and show that there's, you have at least enough sort of evidence that a jury should hear your case, then you go forwards and you go to trial, all right? So this is just on the front end. So this is when you are alleging intentional discrimination. In other words, this company set out not to hire women intentionally, all right? Another way these cases make it in is what we call disparate impact. So this is companies who maybe are using standards that don't appear to discriminate against a protected class on the surface, but they have the effect of doing it. All right? A really famous example is firefighters. For a lot of years, women have wanted to join firefighting organizations, departments, fire departments, right? And pretty consistently, they've been rebuffed. I saw a page that said that, New York City has like 30,000 firefighters and like 3 of them are women or something like that. Very, very small number. How are they keeping women out of those jobs? Well, they'll set job standards that don't say anything about gender, but they have the practical effect of discriminating. So like a height and weight standard. A lot of fire departments will say you have to be 6 foot tall, and you have to weigh 200 pounds, and you have to be able to lift 100 pounds over your head, all right? Now, none of those things specifically say anything about gender, but when you look at the pool of applicants who are over 6 feet tall, there are women who are over 6 feet tall, but they're rare. Men over 6 feet tall, more common. So it has the practical effect of screening out a lot of female applicants from the job. So you go in, you make your claim, and you say, it doesn't say anything on the surface about being discriminatory, but it's having an adverse impact. You say, look at this fire department. It's got 300 members. None of them are women. Plenty of women have applied. They've all been rejected based on this height and weight standard. And I don't think the height and weight standard really has anything to do with the job of being a firefighter. Okay? So if the court buys that, then you move and you shift the burden over to the employer. The employer's got to say that the standard is job-related and consistent with an actual business necessity. So what does a fire department say? Well, you got to be tall because you have to see into windows, right? You might need to see if there's somebody in there that needs saving. You have to lift 100 pounds over your head because the ladders are heavy, right? You have to weigh a certain amount of pounds because, this is hard physical labor. Whatever standards they might give, okay? If they can satisfy the judge, that's plausible. Then it comes back to the plaintiff. And then, again, you got to show pretext, or in other words, your claim that this is a made-up standard intended to keep out a certain group. So how do you do this? Well, you hire somebody like from this department, from management organizations, because we do functional job analyses. I'm not saying actually hire us. This is not a commercial for our expert witness services, but you hire somebody like that who is an HR specialist, and you have them do a functional job analysis, and you say, well, how often do you actually have to lift 100 pounds over your head? We did a study, and we found that happens less than 1% of the time. How many times are you looking into windows over 6 feet tall? Well, we did an analysis, and that happens less than 0.5% of the time. So this is a pretext. And then the defense will get their own witness, expert witness, who will say, no, it's really important. You need to do it. My study shows that you have to do it 25% of the time, whatever. So you have a battle of the experts, and then you go to trial, and obviously the court or the jury is going to choose one or the other, whoever they find most believable. But this burden-shifting framework, it's intended really, I think, to protect employers from like a frivolous suit or whatever, because it throws it first on the plaintiff. The plaintiff's first got to meet this kind of initial burden. But if they do, then it kicks back to the employer, and then they've got to make a showing that what they're doing is legit, and then it kicks it back to the plaintiff. And of course, once you get to trial, the entire burden of proof, as in every case, is on the plaintiff. And this is civil litigation, so we're talking 51%, right? Burden of proof, more likely than not. So just keep these two general kinds of discrimination in mind: disparate impact and disparate treatment. So I told you there were hurdles that you have to go through before you can even get to court with one of these claims. How does that work? Well, if you believe you're discriminated against at work, you file a claim with an administrative agency. So we get back to our admin law chapter. All right, on the federal side, the EEOC supervises all employment-related stuff in terms of discrimination. We have a state equivalent agency and we have local equivalents that I'll show you as well. You go online, you start a claim, and you have a very limited window of time. Generally, it's 180 days from when the discrimination took place. That sounds like a long time. That's almost 6 months, right? But it's really not, because suppose you apply for a job on January 1st, and you don't find out a decision until March 1st. And then you hear about the person who did get hired on March 15th, and then you think, well, I was discriminated against. Well, you're already, 75 days in there? Then you have to go around, get evidence, hire an attorney, file a claim, and you have to have proof to back up your claim. That 180 days goes very, very quickly. In some circumstances, you have as long as 300 days if you're filing it with a state agency as well. But this is a very, very, very short statute of limitations, all right? Most other claims, you have at least 2 years, like personal injury, malpractice, things like that. That's much more reasonable amount of time to file a claim. This is very accelerated, and I think it protects the employer, basically. And if you file a claim, then I think I might have mentioned to you guys something called the exhaustion of remedies doctrine, which just means that if you are in an administrative process and you want to get out of that admin agency and get into the court system, that you have to go through and hit every hoop within the admin agency. So when you file a claim with the EEOC, first they do an investigation. You file the claim, they send you a bunch of questions you have to answer in writing. They're similar to interrogatories. They send them to your employer or the prospective employer as well. They have to answer those. There's a certain amount of time. Then the EEOC or the state agency is going to look at it and see how big of a case is this, how egregious are the allegations. They may look at it and say there's absolutely no merit to this plaintiff's allegations, and then they'll just dismiss the case and you're done. Or they may say, this is a really bad deal, this employer is acting very poorly toward a lot of people, and we're going to pick this case up and we're going to go forward and essentially prosecute or act as the attorney for the claimant. So that usually won't take place with a single claimant, but maybe if you have a whole class of people who file a complaint that are being discriminated against, maybe they'll pick it up. It's very rare. I can only think of maybe 2 or 3 recent Iowa cases that were big EEOC investigations. Typically what they're going to do is, if it's not on either extreme, they may try to schedule a mediation between you and the employer and try to work it out, or they may just issue a right to sue letter, which is saying, it's kind of a certificate and saying, okay, you've gone through, you've exhausted all the administrative remedies, we've decided we're not going to pick up your case. If you want to go with it from here, here is your ticket to go out to the court system. And you usually would end up in the federal court system with those claims, okay? You have to pay your own attorneys all the way through, unless and until you win. If you win your case against the employer, then they are usually ordered to pay your attorney's fees. but you have to float the attorney that far. And then, of course, there can be appeals in the court system beyond that. Okay, so what are some of the big laws that we have regarding discrimination and equal protections in the workplace? Many of you would be surprised to know that we have had an Equal Pay Act since 1963. It purports to make it illegal to pay women less than men for the same work. Obviously, it's not working so well. Okay? Some estimates show that women make about 77 cents on the dollar for the same work as men. And you say, how can that be? It sounds like it's illegal. True. The act has a lot of kind of loopholes or exceptions that swallow the rule. So you can pay women and men differently in a bona fide seniority system. What's the problem with that? Well, women don't usually get to senior positions as quickly as men because men are already in those senior positions and they don't want competition. All right? So until we have kind of an equal number of men and women in management, it's going to be harder for women to get there. And that, as you can see, is a tough cycle to break. A merit system of pay can differentiate based on gender. What does merit system mean? It can mean a whole lot of things. So that can be used problematically. Piece rate, which is kind of like getting paid for your output, like in a factory setting, can discriminate. And this big loophole, differentials not based on gender. So I think the act is well-meaning. It has not accomplished what it set out to accomplish. We still have a lot of work to do here. But it is technically illegal to pay women less than men for the same work. The '64 Civil Rights Act is really the big one that sets out a lot of our employment law equality stuff. All right? And we talked about the '64 Act in the constitutional law section when we talked about serving people of different races at a restaurant or hotel. You know, we talked about how there were just kind of sweeping legal reforms during this time, making it illegal to treat people unfairly based on a protected class. So protected classes we have here: race, color, religion and creed, national origin, and sex. The same ones, or meaning gender. So those are the same ones that we saw back in the con law section. And this act applies to any employer that has 15 or more employees. So in other words, the federal law applies to pretty much all but really small businesses. Now, I want to tell you that we have state equivalents to this as well, and in Iowa, those state civil rights laws apply to anybody with 4 or more employees. So that makes it even a little bit more protection. It sweeps in more companies, all right? So the EEOC administers and enforces Title VII. And, I mean, essentially, what it says is you're not allowed to discriminate against people at work based on those protected classes. There are a few exceptions. You may have heard the term BFOQ, bona fide occupational qualification. So these are some very narrow and limited circumstances in which a company could discriminate against employees based on a protected class. Okay? Some schools are religious-based, and when they hire faculty, they say, we want somebody of this religion. Okay? If they can show that that's really important to their teaching mission, then that's okay. Certain high-level national security positions with the U.S. government may require U.S. citizenship. We know that all the law around national security is a little bit different, but in that case, you know, if they can show that's a BFOQ, then okay. Situations where, I don't know, locker room staff members is an example here. I'm not really familiar with a locker room that has employees working in it, but I guess you could make an argument there that they ought to be the same gender as the people who are in the locker room. I've never really worked out anywhere where that was the case. But in all of these, remember, if the employer is going to raise these as a defense, then the employer bears the burden of proof on all this, because we really don't want discrimination. So these are very, very narrow exceptions, right? In general, if you're applying for a job, they shouldn't ask you what your religion is, or they shouldn't ask you, oh, O'Malley, is that an Irish name? Do you have Irish heritage? Or something like that. Like, those kind of questions really are not BFOQs. I mean, maybe there is some example where it was really important that you have Irish heritage or something like that. But in general, it's interesting. Students come to me and, they say, well, the employers ask me if I plan to get married, or if I plan to get pregnant, or if I like to drink, or if I'm a certain religion, or if I'm not a certain religion. And, those are not legal questions to ask. At the same time, it's kind of hard to deal with that in an interview setting. I mean, I think the best way to do it is just to kind of talk around it and move on. But a lot of employers don't understand how narrow this BFOQ thing is. Really should only be asking work-related questions. After the 64 Act, we get the 91 Civil Rights Act. So some updates. Protected categories: race, color, religion, sex, national origin. So basically the same as what we had before. I think creed and religion were kind of folded together. You don't need to know that for the exam. Creed is just, as we said earlier, creed is a belief system that may not be a recognized religion, but that you follow. So pretty much same protected classes. This is the act that set up that burden-shifting framework that I told you about, with the disparate treatment and the disparate impact. And there are some cases like that Young versus UPS and the other McDonnell Douglas, I think. Other cases that interpreted that. 91 Act keeps the same size of company as a minimum, 15. Again, Iowa has 4 employees as their minimum, so we do have a state equivalent to this. Now, interestingly, the Iowa state law sweeps in more protected classes, and you can do that, all right? States can protect more classes of people if they choose. They cannot opt out of the protections in the federal law. So say, I always pick on Alabama, so let's pick on Mississippi. Let's say Mississippi decides we don't want to protect gender as a class, okay? They don't get to choose that. They don't get to opt out. This federal law controls over that. But if they wanted to add a protection, like veteran status or something, they could do that, all right? So Iowa adds in a couple protected classes. They've got race, color, religion, sex, and national origin. They also add in pregnancy, age, and disability. Now, folks have protections for those things at the federal level as well. They're just in separate laws. We'll talk about 2 out of 3 of them. But in Iowa, your employer is not allowed to discriminate against you based on any of these 8 categories. And it covers entities with 4 or more employees, so all but really the smallest companies. There's a third layer of regulation in some places, okay? Cities or counties can add more protections for their citizens as well. Much like the federal and state thing, they cannot opt out of protected classes, but they can add additional ones. So many of the larger cities, larger towns in Iowa have their own civil rights commission that creates ordinances protecting people from discrimination. And much like the EEOC or the Iowa Civil Rights Commission, you can file a complaint with them. They can investigate it. You can have a hearing there, all of those administrative functions. So Iowa City prohibits discrimination based on race, creed, color, religion, national origin, age, sex, disability. We've covered all of those. Also, marital status, sexual orientation, and gender identity. So those are protections you have within Iowa City, but not within the state of Iowa or the U.S. as a whole. Okay, so we can create more protections for folks here. There was a move to strip this power away this year, but that did not make it through the legislature. Okay? So age discrimination, I told you that's covered under the Iowa Civil Rights Act. We have a federal law that does that too, the ADEA, Age Discrimination in Employment Act. And it comes in to cover anybody who's got 20 or more employees. Why 20 instead of 15 for the other ones? I don't know. It's a weird distinction. Don't ask me. But in the federal side, it covers anybody who's 40 years old or older. Note that in Iowa, our age discrimination stuff covers any employer with 4 or more employees, and it covers anybody who's 18 or older. So we have a huge age range that is protected in Iowa, not so much on the federal side. So when do you see an age discrimination case in the workplace? Typically, it's older people who are let go because they have achieved a certain level of seniority and a high salary, and the employer wants to replace them with someone younger or cheaper, younger and cheaper, all right? It's illegal to do that. Now, if somebody is performing poorly or they're not doing their job and they just happen to be old, sure, if they're at will, you can terminate them. But I see a lot of employers do really stupid things like they identify, okay, all these guys are over 50 and they've been here for 30 years and they get a raise every year. We have to keep giving them a raise. And they're making twice as much money as these younger guys who are doing the same job. So let's make a new level of management, promote all these guys to that level, then eliminate those positions. Boom. Perfect, right? Not illegal. Yes, totally illegal. And if there's one group of people that you don't want to tick off, it's old guys with money. Because all of a sudden, they're in a great position to sue you for age discrimination, right? If you lay off 10 old guys with a bunch of dough, they're going to talk and they're going to get lawyers and they're going to come after you, okay? So I don't know why companies screw this up, but they do, all right? One of the cases in your book, O'Connor versus Consolidated Coin Caterers Corp., quadruple C, great name. 56-year-old guy was fired and replaced by a 40-year-old guy, right? One geezer out, one geezer in. And he sued and said he thought, well, age was the factor in letting him go. And the company said, look, both of you guys are covered by the ADEA. You're both old as the hills, right? You happen to be old at 56, but he's old at 40. We can't be discriminating because we hired another old guy. The court didn't buy that. They said, there's a 16-year difference. Doesn't matter, they're both in the protected class. That could be illegal discrimination. Religious discrimination. So generally, you have to accommodate your employee's religion as long as it doesn't create an undue hardship on the business. You know, what form can this take? Maybe somebody needs a religious holiday off. Maybe they need to wear a specific kind of like headgear or some kind of clothing. You know, very kind of minimal things. Ordinarily, you have to accommodate those. Now, the undue hardship bar is pretty low. However, I was sharing with somebody before class that there are some cases going on in Wisconsin where some folks work in a factory setting and their religion requires them to pray a certain number of times each day on a certain interval, and the boss is saying, well, I'm not going to let you off the production line for that. If you can do it on your lunch break or the scheduled breaks, that's fine, but I'm not going to accommodate, you know, a change in shift for you guys. And so some of them just left. Some are suing under a religious discrimination thing. I'm not aware of the outcome of that case yet. But in general, if it's not a big problem, you just try to work with your employees. Now, what about disability law? All right? This comes into discrimination as well. Okay? So the general idea behind disability law is that you're not allowed to wrongfully discriminate against employees who have disabilities or applicants for jobs. All right? I think it is really one of the most misunderstood areas of employment law because employers freak out and they think, well, you know, I think people with disabilities get an unfair advantage because they get accommodations. Now, anybody who's ever had a disability or has a loved one who does knows you're not getting an advantage. The whole purpose is just to put people on a level playing field, okay? So how do you define a disability under the law? Well, it's very expansive, all right? We have the Americans with Disabilities Act, and then that was amended a few years ago, so now it's the ADAAA, Americans with Disability Act Amendments. A disability is just any physical or mental impairment that substantially limits one or more major life activities. And there is a list of suggested things that are automatically disabilities, but it's not an exhaustive list, okay? So it's anything that affects your ability to do a major life activity like seeing, hearing, walking, lifting, bending, working is a major life activity. So, I mean, in theory, I wear contact lenses. I mean, because I have bad long-range vision, so I guess that would be a disability under the Act. Now, my employer is not required to do anything. I buy my own contact lenses. But what if you have a bad back? Okay, we have folks in the building who are older, and they have a bad back, and they can't sit for a length of time. So they want a standing desk, something about this height, so they can stand and type and do their work. That's an example of accommodating an employee with a disability, right? If you had a wheelchair, I don't know if you guys know this, but there's a little elevator over here. My guess is that it's there because there's no way you could safely get a wheelchair down these steps, right? I think that would be like a cannonball run kind of thing. I don't think it would be very safe. So I'm guessing for faculty or students who use a wheelchair, that elevator is there to get folks in here safely, right? Disability, there's a list of things it doesn't cover, things like kleptomania, which is compulsive stealing, pyromania, current illegal use of drugs. So I had a student once, a master's student who, we were going over the list of, we were talking about workplace respect and workplace bullying, and she said, boy, I worked with this guy for 2 years, and I actually ended up leaving my job because of him and coming back to school. He was horribly abusive to everybody. He was a terrible bully. But HR said we couldn't fire him because he came to work drunk every day. And they thought alcoholism was a disability that we had to accommodate by keeping him in his job. No, that is not how it works. There are specific carve-outs that say if you're on drugs or alcohol, this does not protect you. All right? But that's an example of how people misinterpret disability law and freak out. And there's nothing to freak out about. All right? The law is very clear, and it's usually very easy if you have a conversation to work it out with your employees. Now, here's one of the key words, qualified. All right? You're not required to accommodate an unqualified candidate or worker. Okay? So if somebody applies for a job, like I was looking at, they send out a list of all the open jobs in the college, and there is an open job for the head of a department here in the College of Business, and it says you have to have a PhD in that subject. When they mean you have to have a PhD in that subject, that's what they mean. You need that to do the job. How else would you do it, right? To be a department head and rule over a bunch of professors who also have PhDs. Now, if a high school student comes in and says, hey, I have a disability and I don't have a PhD, you need to accommodate me, give me a PhD so I can do that job. Do you have to do that? Of course not. But a lot of people don't understand the term qualified person and they freak out, okay? So the ADA is meant to protect people who, with or without an accommodation, can do the job, right? Can you do the job? Do you have the skills, the experience, and the education, but maybe you have some kind of limitation that can be accommodated, and then you can do the job, right? So the employer has a legal duty to make reasonable accommodations for a person who has a disability or who acquires a disability on the job or while they're working. And it just says it's a reasonable accommodation that does not impose undue hardship on the employer. So maybe somebody starts to lose their vision, over the years. So you get them a larger monitor. Maybe somebody loses their vision all the way, and so you get them software that turns the text into speech and a Braille keyboard. Maybe somebody hurts their back, you get them a better chair or a standing desk. The way that comes about is the person brings up the fact that they have a disability to the employer. They say what the limitations are. The employer is supposed to enter into a conversation with them and figure out what they can do to accommodate them. And if it's possible to accommodate them without an undue hardship, then you're supposed to do it. All right? Generally, the employer pays for the accommodation. They don't have to pay for something that is super, super, super expensive or that would cause big problems in their business, because that would fall in the undue hardship exception. In that case, they might say, look, the only accommodation that would work for you is too expensive. We can't do it. I'm sorry, we just can't do it. The key thing is that the reasonable accommodation is not intended to put the worker ahead of others. It's just to make a level playing field, right? So just like folks sometimes have accommodations with testing and they need a quiet room or they need a half hour more time or something, that doesn't put them ahead of other people. That just makes it even. Defenses from the employer side to a claim of disability discrimination. Well, there are some things you don't have to accommodate. Like say you're a hospital and the position is a nurse, and say that the employee you had as a nurse became HIV positive, and they were in situations where they might exchange blood with other patients, okay? You don't have to accommodate that. So if there's like a health and safety risk, then you don't have to accommodate it. Say you get a really bad and persistent infectious disease and you work at Subway and you touch people's sandwiches and sneeze and cough on them, right? They could probably say, we're not going to accommodate. We can't accommodate you. That's the only job in the store. It's handling food. You're sick. You're transmissible. We can't do that, okay? Now, what about a whole separate category, but still within this discrimination? And this is sexual harassment. And you say, well, harassment is bad behavior. It's targeted at somebody. How is that employment discrimination? Doesn't that fit somewhere else? It actually fits here because generally, people presume it's motivated somewhat by gender. That doesn't mean it has to be somebody of the opposite gender that's harassing you. It can come from the same gender. But it is a form of discrimination. Definition of it: unwelcome verbal and or physical conduct of a sexual nature in the workplace. There are two main types that you normally see. Quid pro quo, it's Latin, this for that. So this is the sleazy boss that says, well, hey, if you sleep with me, I'll give you that promotion. Or if you don't sleep with me, you'll never get that promotion, right? So that's one kind, obviously a very blatant kind. The other way it comes about is a hostile work environment. So this would be people making, a bunch of sexual jokes or touching people, in sexual fashion, watching dirty movies on their work computers, all right? If you ever want a crazy read, look up some sexual harassment cases. Maybe not, actually. They're not that much fun to read. But you would be amazed at how stupid people get at work. I read one the other day that came out, and they had it was some company. It was not a factory. It was an office setting. And they had a tradition where on somebody's birthday, they'd tie them to a post and take their pants down and paddle their bare butt with a paddle. And there's somebody who didn't like that, and they were like, I don't want to do that. And they're like, it's your birthday, tough. Why would you do this, right? Why would you do this? Okay, but people get crazy. I guess they get bored at work. So those kind of things are a hostile work environment, obviously. It's not always that blatant, but I'm always surprised at how stupid people act sometimes. Now, I mentioned earlier it didn't have to be an opposite gender interaction, and it's not limited just to women. So you can be male on male harassment, female on female, cross purposes, whatever. On-call versus sundowner was a case that was men on an oil rig. And if you want to talk about guys that are bored and doing really stupid stuff, that case. Guys out on an oil rig engaging in all kind of terrible behaviors against each other. And of course they can't leave because they're on the middle of the ocean. And the Supreme Court said that, yeah, men and women are both protected under this. So when does this kick in, and who are the people that can commit sexual harassment? We always think of the example of the boss, right? Like the sleazy boss, quid pro quo. You know, you do this and you'll get that promotion, all right? So that's definitely one instance. You know, any kind of tangible employment action that is conditioned on a sexual favor, or hiring, firing, failing to promote, change in benefits, all those things. If you do that based on some kind of sexual motive, then yeah, that's fair game for a sexual harassment suit. Also could happen in the context of other employees, coworkers, even customers or vendors. So one of my master's students works for, let's say, a large manufacturer of automobiles. And these automobiles are sold by franchises. And it was her job to go to various franchises within her territory, representing the parent company, and, you know, trying to help them achieve their sales goals and objectives. Well, there was one franchisee who was a male, and he was a dirty old man. And she hated going out to see him because he began to, you know, create this kind of hostile sexual banter towards her. Now, he was not an employee of the parent company. He was a franchisee doing his own thing, running his own business. However, she went back to the parent company and said, look, this franchisee is doing this stuff. You got to rein him in. And the company was very good, and they went to him and they said, if you don't stop this right now, we're canceling your franchise. You're done. Okay? If they had failed to do that, she could have had a suit against her parent company. Because if they know what's going on from vendors or customers or coworkers and they don't do anything about it, then they become liable, right? So if you let people know this is going on and the company just kind of poo-poos it, well, they're opening themselves up. So what is a hostile environment? I always get questions from people because they're scared or a little paranoid. Well, I told one dirty joke to a coworker. I thought she'd think it was funny, and she didn't think it was funny. Am I going to get sued? Probably not from one dirty joke, okay? One dirty joke is not a good idea by any means, but it's not a hostile work environment. Usually, these are sort of an ongoing pattern of behavior. Now, it's not to say you couldn't do one really awful thing and create a hostile work environment, but the court looks at these different factors. They look at how frequent is it, how severe is it physically threatening or humiliating? Because if it crosses the line into physical behavior, that makes it more likely to be actionable. And does it unreasonably interfere with work performance? Okay? So, all of these cases are fact-based. You read about companies where the guys are sitting around watching porn all day on computers that are visible to the rest of the office. Yes, that is a hostile work environment. You ought not to do that. I had one student who got really angry about that, and he said, well, I watch porn at home. Why can't I do it at work? I said, man, there's a lot of things you can do at home that you can't do at work. It's not a good idea, right? So, the court looks at it and they say, well, it's either objectively hostile, and any reasonable person would find it so, or perhaps the plaintiff experienced it this way. So to some extent, you take your plaintiffs as you find them. The plaintiff still has to make the burden of proof in these cases. They still have to show it was a hostile work environment, but people have different standards. So personally, I think the best advice I can give you is just keep the sexual stuff out of the workplace 100%. Then you never have to worry. Do employers have defenses to these suits? Of course, right? So if somebody does make the employer aware of it, and they take action to prevent it and correct it, and maybe they make some corrective opportunities available to the employee who's being affected, and the employee doesn't take advantage of them, that could be a defense. So it's like, okay, we know Bob over here in Unit A is a perv. We're willing to move you to Unit B where you won't work with Bob. All the pay and benefits are the same. You're doing the same kind of work. And if the person said, no, I'm not leaving the unit, maybe that's a defense. You don't want to get in the position of having to raise these defenses. If you're sued for sexual harassment, it is expensive and embarrassing. So it would be best to use education and proper HR practices to keep it out of the workplace altogether. So this is what I have for this. We will come back next time, and we'll further talk on workplace respect.